royalty in the strict sense and common parlance may not be a tax. It can be viewed as a kind of tax, which is why 366(28). Linked either directly or indirectly to the intrinsic economic value of a mineral realized through sale by the lessee. Royalty of mines cannot be a fee, but a levy in the nature of the tax. Then next page, Balas, 333. Royalty on coal is a tax. International Monetary Fund, Malas, not that it's at all in any way binding, it's a working paper. I've quoted that, don't read it, it's saving time, Malas. I've quoted it there, please look at it. Come to B24, which is on general interpretation, Malas. Your lordships can use an external aid, because these are some of these external aids to interpretation. And now, Malas, just note on the side of B25, a conceptual point, which is not put like that. Your lordship has taxes which are royalty under 9. This lordship I have not put here, lordship I want to note on the side of B25. Royalty is a tax under 9. Dead rent is a tax under 9A. DMF is under 9B. Only thing which I get a quid pro quo and a benefit is the fourth one, NMET, the exploration tax. That is 9C. That can go in the category of fee, but it's an impost covered under 366. It's the fifth one which came in 2015 in my B25 para, which is a bidding parameter. That is contractual. That is not a tax. This what happens is, Balas, after the auction regime of 2015, I have to bid. So I bid 10 rupees, he bids 20 rupees. On that bid of mine, depending on the bid, I have to give a share. That's my contractual thing. That's the fifth one which has come only in 2015, which I have quoted in B25. All the other are compulsory exactions. I'm only contrasting it. It's called a premium, but it's actually a contractual exaction, a contractual payment. And that is the closest to a share or a consideration. I'm contrasting it, Balas. And your lordship, Balas, has got the B25 and B26 on that. Now, Balas, I come to the other contrapoint. If it is a tax, Mr. Singhvi, how do private persons collect it? Very simple answer, Balas. Let me give the answer first and I'll read the rule. Well, it is true that it is a relic of the constitutional past. But the tail should not be allowed to wag the dog, as was mentioned yesterday. This will be a case of tail wagging the dog. It is a very, very few number of states, and my learned friend relies on Theresima, Mr. Devedi cited it, which was Kerala, which had forgotten, I would use the word forgotten, to pass a law saying that the mineral under the earth is the states. Incidentally, after Theresima, Kerala immediately passed that law. Most other states, 99% have that law. It is true that there may be one or two examples, which I call a tail, Malas. That will not decide a 9 judges approach. That royalty is not a tax because 0.1% cases may be there in the country where the mineral does not vest in the government and therefore there can be a private lease for which royalty is paid. That's answer number one. Answer number two is very interesting, Malas. Is that even in those private lease cases, the 2016 rules make it clear that it is completely controlled by the government. Because the private man, he's the private lease owner, he can't give me a lease. He has to go through a gamut of prior authorization by the government under 2016 rules, which I'll show in a minute. And the third reason is most important. This private leaseholder cannot enforce through 25. That's the hallmark of a sovereignty of a tax. So, Malas,
what is the third reason?
Third is this private fellow who has a relic, Malas, a few occasional leases here and there in the country which have not been taken over by the government, cannot use 25 to enforce. The enforceability is given only to the Malas exaction. Section 25 is clear. Now, just read the para in that light. 3 points I have given, Lordship. All three are covered here.
Sovereign function.
So, B27 of my page, Malas, 334. 334 is the Theresima Kerala case.
Yes.
At B27. At 335 page number of my written submissions, I have said in the first 3 lines, there was an absence at that time of a provision in the Kerala land revenue declaring the ownership of minerals underneath to vest with the state. That is, Malas, one of those anachronisms. There is hardly a place, 99% would not be that. It's a relic of the pre-constitution position which I have said. I don't want to read it, Malas. Second B28 is the section 25 point, which I just made. B28A, section 25 and 21 bracket 5, the recovery positions provisions would not be available to private lessors, thereby changing the very character of royalty. The grant of mining lease concessions by private person is not unqualified. Now see this authorization in rules 27. Where do they? There is that book you also have to take to downs. Actually, although the private man has the lease, he can't sneeze without permission from the government. All of it is regulated.
All right,
Well, rule 27 is not given here in this bunch, but your lordship has that book.
yes.
It's got a 2016 rules, which says for a private owner of a lease to even negotiate with him and give it to him, everything is covered by prior permission or authorization. He can't. And this is true of minerals other than hydrocarbons and atomic. In hydrocarbon and atomic, of course, there's no question. It is already gone with the state. But for all other minerals, every other mineral. So, it is a relic. It's an argument used to decide the main matter where 99% leases are not there and lordship is, it is true factually. I can't deny it. But it just doesn't make sense to interpret it on that basis, my humble submission. Now, that's the 2 points. And lastly, as I finish my first proposition, just see that 4 months later judgment by the same learned judge who presided over India Cements and how he understood tax. Kindly see the Honorable Chief Justice in volume 5I, page 67. Starts at 65 at 67. He presided over India Cement. The learned judge who presided over India Cement, 4 months later in a follow bench. Oh, come on, give it now, give it. And I will always hearken back to that question. What is so specially wrong about India Cements? Or what is so specially correct about Kesharam?
Which part is that?
Para 6 at page 67. That this entire established law should be changed.
Months after the.
I'm sorry, not 4 months, 2 months after India Cements. 2 months after India Cements. Well, the Chief Justice, as he then was, says, we do not find much substance in this contention. Does my Lord have para 6?
Yes.
Recently, a constitution bench of this court has held in India Cement. Recently is 2 months earlier. That the royalty levied on the extracted mineral was the nature of a tax and not in nature of a fee, which could be used only for specific purpose. Any tax realized, etc., consolidated fund of India. I'm not reading, but save time. Well, all this is happening because of 5-judge bench, at least judicially, has set the cat amongst the pigeons. Unless there's some overwhelming reason why a lordship should not follow a 5-judge bench. Otherwise, the law was very clear, understood as clear. Coming to my second proposition, I must race along. Dead rent is the second proposition. At page 335, it starts. Is clearly even a fortiori a tax. As your lordship knows, the scheme is central government occupies in 9 the royalty. In 9A, it starts occupying the dead rent. Well, I would like to call a dead rent an idling charge.
It is made to the government. Will a minimum guarantee payment also be partake the character of a tax? Because in a large number of situations,
Yes.
a minimum guarantee payment is assured to the government, whether it's an electricity company. Where the principle is you must lift electricity.
No. Its answer is very simple. I appreciate my lord's question. It's very important. Nobody can say a minimum guarantee.
Suppose there's a public-private partnership. Government has wants an assurance of a minimum revenue. It says this is you must give me this irrespective of what profits you make.
Straight away. There's no problem. Every example which your lordship has in mind will be contractual. Every example. What are these public PPPs, brothers? One is a BOT highway. Second is a tender. Third is an auction. All contractual. This is, brothers, an exaction under 9A. Your lordship has a clear dividing line and I am not going to be inconsistent, brothers. I've just yet to show your lordship a very interesting statement of objects and reasons when 9A was brought in. Your lordship will be shocked. Every case will fall in the contractual versus the non-contractual exaction line. And that's why 366-28 is perfect. Chief Justice Latham is perfect in Chickering. Followed by 1 9 judge and 1 7 judge in India. Shirur Math and Jindal. Now in this dead rent, first of all the points are the same, 3 elements. Compulsory, non-voluntary, exaction, and what is enforceability. Same. Here the additional point is, it is not based on what you extract.
Nature of a tax.
As a matter of fact, the better way of looking at dead rent is it's a charge on you taxation for squatting or for idling. You just idle. Either while 100 Tusharmehta gave a reverse example. I would think the better example is that you sit and do nothing. He gave an example that you overexploit early. Suppose you do nothing. You are depriving this man from getting it. You are not contributing to the country and you're sitting idling. So dead rent comes in. Irrespective of whether you extract or not. Now, in this, B31 straight away is extremely important. This also was in Form K. It was transposed from Form K in 1972 and put in the section. This is apropos the Honorable Chief Justice, very important query. Of course, according to me, it was statutory even in Form K. There was no doubt about it. But after 1972, the issue vanishes. It is made a special statutory provision with a capital A. That's by para 31, B31. Now, in 72, they brought in two sections together, 4 capital A and 9 capital A. I hope I'm clear with this. And the object, the SOR of 4A, which I am reading from the note itself rather than taking your lordship to save time, is very, very, very interesting because it replicates the language of 54. It reads, so as to enable mineral development of that area by a government, company or corporation. This is, lordship will get in volume 4, 915 and 916, but don't go to it. It will save time. It's quoted by me here.